14th Amendment to the United States Constitution was adopted after the Civil War. Ratified in 1868, it is the second of what became known as the Reconstruction Amendments, and it effectively overturned the infamous Scott versus Sanford decision, in which the Supreme Court had ruled that African Americans were not citizens of the United States. The 14th Amendment also guaranteed all persons the right to due process and equal protection of the law.
We have to remember in the context of this amendment that the United States had been through 4 years of as brutal a civil war as the world had ever seen before. And most people believed, rightly so, that slavery was at the heart of that. And so in an attempt to reconstruct the United States, Congress passed the amendment that would guarantee once and for all citizenship rights and equality for African Americans. Even though the Civil War was over and the Confederacy had been completely defeated, it didn't change the hearts of many people in the North and in the South especially when it came to equality and the notion that African Americans could be treated equally with the white establishment. And so from the very beginning, the Civil War amendments, and the 14th Amendment especially, was frowned upon by, the traditional ruling class of the South.
There was a lot of resistance to just about everything that Congress was trying to do at that time. The Southern states in particular still felt that their ability to force black people to work was being infringed upon.
In many of the Southern states, they adopted so-called black codes, which essentially reduced recently freed slaves to almost a status of slavery. They were stripped of virtually any significant civil right. And in reaction to that, the Reconstruction Congress passed the 14th Amendment, which was designed to do several things, but one of the things it was designed to do was to provide a remedy against the so-called black codes. Now, the problem that the South had was that they had seceded from the Union, and although under the theory on which Lincoln fought the Civil War, they were still part of the Union, nevertheless, they had lost their political power in Congress. Certainly, the Southern jurisdictions, had they had the opportunity, would not have favored the 14th Amendment and the Equal Protection Clause, but essentially they were outside of the system trying to get back in.
They were governed militarily, essentially like conquered territory, and they were told that they would not be readmitted to Congress at the United States unless they ratified the 14th Amendment. So the 14th Amendment was, in effect, ratified by coercion.
They didn't like it, and they didn't cooperate with it, and slowly but surely, as the Civil War retreated into memory, people began to reassert white supremacy, especially in the southern states, but in the North as well.
In 1875, Congress passed the Civil Rights Act of 1875. One piece of this legislation guaranteed African American citizens access to what was called places of public accommodation. This meant that by law, African Americans were allowed full and equal access to theaters, hotels, restaurants, and public transportation. Basically,
Whites still didn't accept African Americans as equals. So Charles Sumner, who wrote this particular bill, proposed it, and Congress passed it to ensure that people would not be discriminated against on the basis of race in public accommodations and public facilities.
We have to remember that in 1875, Congress was controlled by a group called the Radical Republicans. And they were the ones who were the ones most likely to get back at the South for causing the Civil War in the first place. And the Civil Rights Act of 1875 was designed to empower African Americans politically, socially, and culturally.
But this legislation was rarely enforced, and as the years passed, people in both the North and South grew weary of Reconstruction. By 1883, the law was challenged in the U.S. Supreme Court. In an 8-to-1 vote, the legislation was overturned.
The Supreme Court basically said that the Civil Rights Act of 1875 only applied to states. That is, states couldn't pass laws that discriminated against people on the basis of race, color, and previous conditions of servitude. But they sort of drew the line and said, well, individual citizens should be able to discriminate. For example, if I don't want you in my hotel, I should be able to determine that you can't come in there. If I don't want you in my restaurant or in my theater, and it's my property, I should have the right to make that decision about who can and can't come into the accommodations that I'm providing. It just literally gave businesses and restaurants, hotels, theaters sort of carte blanche then to begin to set up new Jim Crow or segregation laws, and it sort of legalized segregation, at least in public accommodations.
When the Supreme Court struck down the Civil Rights Act, it was just one in a series of events where progress towards full equality for African Americans was halted, and in some cases even reversed.
The promise of equality under the law suffered another blow in 1896 when the Supreme Court decided the case of Plessy versus Ferguson. Homer Plessy, a man of mixed race, had been arrested and fined for sitting in the whites-only passenger car on a train in Louisiana.
Homer Plessy was a citizen of New Orleans. He was an octoroon. That is, he was 1/8 African American in terms of his heritage. And in fact, I always tell my students, he wasn't even visibly black. If you saw him, you would see essentially a white man. He and some other citizens who were fighting for equal rights in the city of New Orleans decided to use Homer Plessy to take a train from New Orleans to Covington to test this new law that the state of Louisiana had just passed.
He knew precisely what he was doing, and he was aware of a strategy by some of the New Orleans Creole population to challenge that law. When he went onto the railroad car and identified himself as African American, he knew he was going to be thrown off the car and be arrested, and that was the beginnings of the Supreme Court case Plessy versus Ferguson.
Mr. Plessy's argument was that Louisiana's Separate Car Act violated his constitutional rights under the 13th and 14th Amendments. The Supreme Court disagreed, and as a result, the doctrine of separate but equal was established.
When the Supreme Court took up Plessy versus Ferguson, they had to guide them the 14th Amendment of the Constitution. And what the 14th Amendment theoretically guarantees is equality. And they ruled that Homer Plessy isn't guaranteed by the Constitution the right to sit wherever he wants. He's guaranteed equality. And if you can separate him in an equal way, it is constitutional.
So this notion of separate but equal becomes the constitutional meaning of the Equal Protection Clause after 1896. And as a result, states and localities pass laws that segregate based on race, and they say we can do this because of Plessy v. Ferguson.
Justice John Marshall Harlan, a Southerner from Kentucky, was the lone dissenter in the Plessy case. In his dissent, he wrote,
"Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. In my opinion, the judgment this day rendered will, in time, prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. The present decision will encourage the belief that it is possible, by means of state enactments, to defeat the beneficent purposes which the people of the United States had in view when they adopted the recent amendments of the Constitution."
Justice Harlan's words were prophetic. Over time, separate but equal would be applied to nearly every public place. African Americans were to use separate public restrooms, separate drinking fountains, separate hotels, separate waiting rooms. Furthermore, Plessy versus Ferguson paved the way for racial segregation in public schools to be sanctioned by law.